Good afternoon, everybody. I'm Elizabeth Beatty. I'm a partner in the district resolution team at Harrison Clark Rickaby's and also the head of the firm's in-house lawyer services. Thank you for joining us today for this session, this time focusing on funding legal advice and litigation costs. We thought this would be a really useful session because the cost of litigation is often perceived to be a barrier to pursuing claims. The reality is that litigation can be funded in a wide range of ways beyond the basic hourly rate. Now, before I introduce my colleagues today, a little bit of housekeeping. This is a Zoom seminar that's being recorded. It's intended to be interactive, so there will be a short presentation from us and then over to you for your questions and comments. The key for us today is that this is part of our series of added value sessions for our in-house lawyer contacts and clients. It's relaxed and it's time for you to pick the brains of our experts. So I think you can either put questions to us via the chat facility at the bottom of the screen. If you'd rather ask questions after today's session, then the contact details everybody will be provided so that you can make contact with them and pick their brains offline, as it were. First of all, we're going to have the introduction from my colleague Simon Beasley, who's a specialist in cost funding. He's a dispute resolution partner, and he's going to look at the various funding options available to in-house lawyers and the circumstances in which they are best deployed. Following Simon's presentation, we'll then open up the panel to field your questions. On the panel will be Simon, and he'll be joined by another dispute resolution partner and our national head of the team, Beynon. So I'm going to hand over to Simon now, who will take you through his slides. Thanks, Simon.
Thanks very much. So good afternoon. As Beth said, I'm a dispute resolution partner in the London office, and I've been a litigator for over 15 years now. The types of matters we deal with are wide-ranging, and our clients are from multiple industries. And rarely are two cases the same. We have in part of our team a sports focus, particularly in London, but our work overall includes things like complex contractual disputes, company shareholder and partnership disputes, cross-border claims, international arbitrations, worldwide freezing orders, all these sort of things of this nature. Probably, in short, the messier, the more complex the matters are, the more likely it is something we deal with. But to be honest, what I'm more proud of is really that we very rarely have any billing or cost issues with our clients. Our cases vary so much, but funding is always one of the key client choices and one of the most in-depth things we discuss early on in matters. So I focus on litigation, which that type of work allows for a much wider scope of potential ways to fund matters than perhaps small, bespoke or non-contentious pieces of work, simply because of the length of time some of our cases can run and the potential cost consequences of them. If you have the next slide. So when I speak to a client for the first time who's instructed other firms, or it's the first time they're using a solicitor, these are some of the words which generally come out, and that is the perception, especially of litigation for some people. So before we get into the cost of anything, really, the first thing we always advise people is check and triple check that you don't have a form of legal expenses cover or before the event insurance. You can find legal cover in the most bizarre policies and places to do with your property, bank accounts, other insurance products you already have from your employers as part of business insurance, as part of liability insurance. And I really would keep hammering home to check them all. I think about 2 years ago, I had a client with quite a complex dispute, and we had an initial chat, and I told him he's got to go away and check these policies, and he swore absolutely blind to me that as director he knew they had no insurance. 2 days later, he spoke to his broker, and they were fully covered. They had all legal cover in place. He had no idea if they even had the cover. So it shows you that the assumption on the part of people is that it's always expensive, but you may already have been insured and paid for that insurance without even realising. Those sorts of legal expense insurance will usually require you to use one of their panel solicitors, at least to the point of issuing a claim. And if you then want to instruct your own choice of solicitors, you'll have to find solicitors that are willing to work on the hourly rates that the panel are working for, which is usually lower, or you to pay a top-up fee. So there are decisions to be made in terms of using insurance, but you always need to notify them early on, because they often have notification clauses, which means you lose the funding if you start to progress a matter and you don't inform them in time. But in my experience, it's not really the expense that is the issue for clients or that upsets people. It's that people are happy to get what they've paid for. So the dissatisfaction I see normally comes from people who are uncertain about what something's going to cost them, or if there's a disparity between what they believed they were going to receive and then what they actually got. The most important thing we find here is that you have a clear scope of work. Before you can even agree what method you're going to use to be billed, you have to understand very clearly the scope of the work that's going to be carried out and the service that's going to be provided. And this is what prevents most of our issues, in that we're always very clear about our scopes of work. The clearer the work, the more specific we are about what we're doing, usually the lower the fee estimate, and the more accurate we can be on costs at the early stages. And we spend a lot more time actually on the scope than you might think, simply to ensure it is accurate. Next slide, please. So the first option that usually comes to everybody's mind is the hourly rate. And we know how that works. And there are very clear pros to using this method. You're only paying for what you get. It's measurable, and it's even how the courts assess costs for recovery. So, as a process, it clearly is established and works. Some people might feel that there are some cons to it, because ultimately work is only as good as the time that's spent on it. And for some people, it is harder for them to budget, because they always have an idea of cost, but it's usually a window. So people have to budget on the worst case scenario, which often isn't the case. Sometimes the initial work especially isn't very clear, and so it's explorative in nature. Therefore, it's far more difficult for us to be accurate with the time. The scope being clear helps this, but when the solicitor doesn't know exactly what the work will entail, it's difficult at that early stage to be able to give more certainty. Next slide. So most people think there's only one or two options as an alternative to hourly rates, but actually there's far more than that. It's just that whether solicitors are hesitant to use them, or don't have experience with them, or people just don't consider it and like to launch straight into the work, there's just a multitude of ways which legal fees can be paid for, and they work very well in different sets of circumstances, industries, and problems. So, set fee, again, we'll all know what that is, but I see a lot of clients who choose this sometimes over hourly rates simply because they want clarity at the outset and to be able to budget it, even if potentially it's higher than the hourly rate, because they want the certainty. And the upside for the client is, if it takes us as solicitors twice as long as we estimated, that's tough to us. We agreed the price for the work, and as long as the work hasn't changed, that's the fee that will be paid. The issue is, obviously, it is a set fee for the work agreed, but if further work comes out of that, then that's not covered by the set fee. And that can be more difficult when work is explorative in nature, because we'll have to estimate on a worst case scenario rather than being able to be more specific as we would with time. So again, scope here is key. And the client needs to assess between these two options what's more important to them, whether to budget or to actually be able to reduce costs and only pay for exactly what they're receiving. The next part is a capped fee, which effectively is very much like a time hourly rate basis, but it sets an upper limit on spending. Again, that's good because it allows what appears to be a hybrid between hourly rate and set fee, because you can't overspend because we've agreed the ceiling. And it's good for when work is unclear, but the client has a very specific or limited budget to get those works done. The downside, however, to that can be, in certain circumstances, that it's not necessarily linked to the outcome. So ultimately, the time is spent up to the fee, and we'll do everything that can be done to achieve what we set out to do. But it may create a situation where more work is required to actually get to the final point where the client wishes to arrive at, but that a cap has been agreed. So it effectively works almost as an hourly rate long stop. I have used this and so forth, but for me, it's not used anywhere near as frequently. And one of the more well-known ways of funding are what's known of old as no win, no fee, but a full conditional fee agreement, which is still incredibly popular and widely used. And for anyone in litigation, the potential risks for you are your legal fees, your opponent's legal fees, and your disbursements. And you're protected with these when using a CFA. And this is your conditional fee agreement is obviously your contractual agreement with your solicitor, but there is an after the event insurance premium that is levied for an insurance product which covers you in case you lose. So if you're unsuccessful in your claim, your insurance product will pay for the opponent's legal fees and disbursements, and potentially your own disbursements as well. So therefore, you're in a position where you're able to litigate a claim whilst being protected from the potential cost consequences of it. Some insurance policies will also pay your disbursements, so things like barristers, court fees, and things like this. And also some policies are self-insuring. So the cost of the insurance product itself is something, even if you're unsuccessful, you may have to pay. But some premiums will effectively pay for themselves if they're unsuccessful. Therefore, for a client in that position who hadn't won their case, the insurance would cover all of those costs. There's big upsides to this for many clients. The protection from risk is by far one of the largest. And again, it gives certainty. It allows you to understand more what you're getting into, what the risk profile is, and that you're protected. Downside is you've got to obviously find a solicitor who's willing to risk their fees and to conduct the work for you. Before most firms will enter into a conditional fee agreement, they need to have a good idea of exactly what the case will be and its chances of success. So some time does need to be spent before you enter into a conditional fee agreement. It's not really appropriate for all cases. And you may still end up, depending on your insurance product, having to pay for your disbursements if you're unsuccessful, or the cost of the insurance. There's also a success fee. So if the solicitor is successful, there is a percentage of the fees that they've charged that is payable on top. And this is to effectively offset against the loss of time for those fees not having been paid, or losing the fees entirely if you're unsuccessful. So it used to be previously that the other side in a claim, if you were successful, would be required to pay both for your ATE policy and the success fee for your solicitors. The rules have changed now that you have to pay all of this yourself, whether you're successful or not. Obviously, that's good and bad. It's bad in that you can't recover your costs from the other side, which is always a preference. And it used to be a way that you had to inform the other side that you had one of these agreements in place, and therefore they knew that you'd assessed and believed you had at least a reasonable case to run. The good side is now that the other side doesn't know how you're funding your cases. The DBA, which is next, is the damage-based agreement, which people might view as a type of no-win, no-fee, but it's effectively a straight percentage of damages recovered. So a solicitor taking, let's say, 40-50% of the damages you recover in full payment for their fees. So they're not being paid as they go along. And these were originally not permitted. The regulations came in 2013 to allow them, but they're still quite tightly regulated. And there's an obvious upside in that you're only sharing what you're awarded. So that's obviously appears on the surface preferable to many people. There are some downsides to this. Again, you've got to find a solicitor who's willing to do this, who's willing to risk their fees on this basis, and if successful, to be paid their fees on this basis. Costs that you can recover from the other side are always capped due to the indemnity principle, which is you can't recover more from the other side than your client is liable to pay themselves. And therefore, the percentage, which may seem a good thing at the outset, may actually end up in insufficient fees being achieved later on. These, I think, are best used if people are very focused and very much want to use them. It's absolutely fine, but therefore quick and bespoke pieces of work where a matter might settle quite efficiently. I don't think I can see many cases where this is a preferable way to fund a case over conditional fee agreements, third-party funding, all of the other options that are available. And that therefore obviously brings us to third-party funding, which is something that's far more popular now in the last 10 years than it ever was before. And this is where third-party companies who are set up for this sole purpose, and that is to part fund claims or fully fund claims for people in exchange for payment from the outcome when it's successful. So it might appear on first blush to be a similar description to how conditional fee agreements work, but they are different. So there's a tri-party contract between the solicitors, the clients, and the funder, and it's not contingent on the costs itself. There's been a case recently you may have seen, which is why third-party funding has again come to the fore. The Supreme Court decided that if one of these funders assesses how it recovers its cost as a percentage of the damages, well, then that's just like the damage-based agreement that I described. And therefore, if it's a damage-based agreement, it's subject to the 2013 regulations. So there's going to be, and there already is, a plethora of cases all coming out now about people trying to establish whether their original conditional fee agreement, their third-party funding agreements are enforceable, whether they're enforceable in part, if the calculation of what they recover is calculated as a multiple of what is being loaned rather than based on what's recovered. So I've seen third-party funding work, extremely well. It's good in terms of cash flow because it means that disbursements and fees are still being paid, usually in part that the funders want to see the solicitors also risking some of their fees, but it does allow for some cash flow. There are a lot more solicitors that will work on this basis than some of the others. Again, as with conditional fee agreements, there would be an after-the-event insurance product in place to protect against the risk of being unsuccessful. And the people that you're working with effectively are risking their money and want the case to succeed as well. Some people feel there are some downsides, though, that again it requires still quite a lot of analysis and an opinion at the beginning, because the funder's going to want to know the specifics of the case and likelihood of success as to what they're going to fund and risk. And the vaguer and wider that description, the more the risk profile increases for them. So therefore, the more money they're going to want. So it's trying to achieve that balance, which can be quite difficult, which has to be done at a fairly early stage. Clients are going to lose a share of what they recover, which is something some people are never comfortable with. The third-party funder is usually involved in settlement and tactical decisions to do with the claim because they have a financial stake in the outcome. And usually, not always, but very usually, that third-party funders really are for monetary claims. They're a business and there has to be money at the end for them to receive some money from. So it depends what the very core of the claim that's being brought is, or if the monetary claim is additional, the likelihood of success and quantum of that. I think they work well for people who have a view that otherwise they couldn't possibly fund a case that they have. They work well for people who take the attitude they'd rather have 50, 40, 60% of something rather than 100% of what they've got but they can't afford to run. And the involvement of brokers initially can be helpful in terms of the insurance products. So you'll be pleased to know that brings me to the last and what I think is one of the best methods, which is the hybrid conditional fee agreement. So this is, by its name, very similar to the original conditional fee agreements, but using a working example is probably the easiest way. If a solicitor is usually £500 an hour, they will still give you a scope of work, still agree with you the amount of costs, but that you would be invoiced and pay as the case went along at whatever percentage you agreed, let's say 50% in this instance. So you would pay £250 an hour, or however it's calculated, you'd be paying half of for your solicitor on the basis that you haven't yet achieved what you have agreed in your agreement as success. Now, once you get to the point where you have achieved what you have agreed between you initially as success, the other half of the fees then become payable. So this obviously makes it lighter on our clients in terms of cash flow by 50%, because they're not having to pay the money immediately to get the case started. And some people like to be able to do that because if the case was unsuccessful, they wouldn't have to pay the other half. And if it is successful, they might feel that they're going to get some money from the other side, and that would help them with their legal fees. Not my favourite phrase, but lots of people, see this as solicitors having skin in the game. That, for us, at the end of the day, we are always out to do the best to win for our clients, irrespective of how we fund it and how we go about it. But for some people, it makes them feel more comfortable to know that our fees are at risk as the money that they're attempting to achieve or the success in their claim. The downside for that, obviously, is that it's still going to pay our fees, at least at the 50% rate. And if we are successful, then they'll pay our fees plus a success fee, which is usually a lower percentage than a full CFA because the risk is less. But again, the firm has risked half the fees for potentially several months to years, and there's the chance that they'll lose them. So the success fee is to balance that out. It can be beneficial, as I think it aligns clients and solicitors quite well, but it's something that people have to be comfortable with, and they have to still be able to budget for how the fees will be paid. And the next slide, please. So why only one method? And the honest answer is it doesn't have to be. You obviously wouldn't run necessarily two styles or ways of paying for legal fees concurrently. You can have two different pieces of work with two different fees. But what usually happens is it's hourly rate or set fee funded to assess and establish what type of claim there is and the evidence and chances of success, because any conditional fee agreement will include risk, as I've explained, and it will do for third-party funders. But if they know potentially what the claim looks like and how successful it's likely to be, it allows people to assess how viable the claim and what they need to receive from it to make it acceptable on their commercial risk profiles. So in short, it's best to establish your claim first and then see after that as well what methods you think would suit the claim. Also, any of these agreements will have a clause that allows you via certain methods to change the way in which fundings happen even halfway through. Usually there will need to be some payment made to the parties if you're going to end agreements early and so forth, but you're not absolutely bound with no way of exiting one of these forms of funding. And next slide, please. Okay, so that's me talking for 25 minutes at you about funding, but I think we've already had some questions in, haven't we, Beth? And if anyone else has any questions they'd like to ask Wayne or I.
That's great. Many thanks, Simon. As I say, Simon said we're going to open up to the panel questions. We have got some questions, which I shall throw out to you and to Wayne. So I've already introduced you, Wayne, but welcome, Wayne. Thanks for joining us today. I'm going to start with in no particular order, and I'll open it up. Either of you jump in, but is third-party funding available for all cases?
Simon, do you want me to jump in on this one?
Yep. Go ahead.
Okay. Thanks, Beth. So the short answer is third-party litigation funding isn't available for all cases. As Simon alluded to, there are certain characteristics of a claim that need to be present in order to attract funders to back a particular claim. And the three main pillars are there needs to be a sufficient damages claim, a sufficient pot of money that you're pursuing. That pot of money that you're pursuing needs to be recoverable. So the proposed defendant needs to have the ability to pay significant damages and legal costs. And thirdly, and possibly most importantly, the claim must have a good prospects of success. So a number of funders in the market will require a leading barrister's opinion about the prospects of success on a particular case. But provided all of those characteristics are in place, then most cases are capable of attracting the attention of multiple funders. And then it's a case of looking at the market and seeing what the best product out there is available. And this may be covered in a moment or two, but the third-party funding market, as Simon was alluding to, has matured so much over the last 10 years in terms of affordability for claimants. When this market first came to the forefront in litigation, probably in around 2008 to 2010, there were a handful of funders in the market, and they were looking for a return of 5 times their investment, so 5 times the costs that they spent on a particular claim, or 50% of the damages that were recovered from the defendant at the conclusion or settlement. So that the money was expensive at that time. And so the number of cases that litigation funding was suitable for was that much smaller. But as I say, the market has matured a lot more and the money is far more affordable. And And what we tend to see now in the market is an approach where funders will stage or cascade their recovery based on the risks that they face during the course of litigation. So their recovery increases the further they move into the litigation, whether it's past issue, witness statements, preparation of expert evidence, or indeed after trial. And on, on occasion, funding can be secured for as little as 1.5 times the funder's outlay, which is particularly affordable for some cases. Simon, I'm not sure whether you've got anything to add there.
No, I think you've covered it. It's the important thing as well is assessing quite what level the monetary part of the claim is. As normally there's multiple heads of claim, not all of them necessarily resulting to the same level of chances of success that result in payment. And obviously, as I think I said earlier, funders are businesses at the end of the day, and they want to know there is money because it protects their risk profile and their likelihood of recovery as well. So I think that's one of the things they're always really keen to know.
It's really helpful, thank you. Sort of another question that's come in is, we talked about the various options today, Simon. Which method of funding do you think is best for legal matters? Now, that's quite a loaded question, but it'll depend on the case, but I don't know if you're happy to field that one.
The funny thing is, I've seen clients make so many different choices in terms of their funding. Sometimes I can absolutely follow their logic, and other times it's totally lost on me. I have some people who would rather pay more on a set fee than to risk the variability, even within a defined window of hourly rates, simply to achieve that level of certainty. So for some people in those sorts of positions, what's best for funding their matters is what their business allows for, if their preference is budgeting, if they have more of an appetite for risk, if they have a better way or a willingness to have funds as a contingency, or whether they don't want to be at any risk at all. I'm definitely a convert to hybrid CFAs. I think they're a great way for clients to see that we are really with them, that as we are with any case, but they can see our money is tied up with theirs in a claim. And very often it allows people to run a claim that otherwise they might not be comfortable with, because very often people start a claim that's either thrust upon them or they weren't budgeting for in that financial year. So sometimes a hybrid CFA that allows them to pay even half the hourly rate at the outset allows them to get through the first financial year where they hadn't budgeted for any of the costs, to then get to next year's budget when they can now allow for the second half and they know far more where they are. I have seen hybrid CFAs work really well. As to which one's best, you probably know that with 100% hindsight. When the case is over, you can look back. It's that sort of educated guess in terms of what the client feels is best for them in terms of getting to the end. I think it's very client specific, that one.
I'd agree with that, Beth, because you mentioned different cases might be more or less suitable to a particular type of funding. That's correct. The point that Simon was making about the client's circumstances is as important, if not more important. There used to be a common misconception around the use of third-party litigation funding, that it was only suitable for claimants that either were impecunious and didn't have the ability to pay for legal fees, or those businesses that needed to free up cash flow, and so were looking for alternative ways to fund their litigation. But now the approach is far more sophisticated than that. And actually, we were listening to one of the brokers in the market speak to us the other day about the way in which legal fees are treated on the balance sheet of a particular business. And the obvious point here is that your legal spend as you move through litigation, particularly high court, multi-jurisdictional litigation, they are large invoices being submitted every month by your lawyers, and they can have a significant impact on your P&L account. And so if you're a business that's looking to refinance or potentially exit and sell, within a 3 to 5 year period, that legal spend will always have an impact on the EBITDA multiplier and the valuation of that business. Whereas if you can offload that financial burden of pursuing litigation, move it off the balance sheet, you know, the picture, the financial picture for any given company looks that much rosier. And of course, you know, even on successful claims, even in the best case scenario where claims result in the recovery of significant damages, when those damages come in, they sit as an asset of the business. They don't replace past, you know, they don't impact on historic profit and loss. So that the position is never really recovered on the client's balance sheet.
That's really helpful. Thank you both. I mean, one thing you both picked up on is, you know, Simon, you mentioned budgeting, when you mentioned balance sheet, you know, the whole thing of, you know, how can you budget for the unknown disputes and problems? Bear in mind that, you know, in-house lawyers, part of a wider business, focuses on the business, and, you know, whereas us as in private practice are focusing on the disputes that come in, you know, we've got our, you know, our focus is slightly different. So how can we help by sort of assisting them in terms of working out the budget and how to approach it? It sort of links back to what we've talked about before, but I just think it might be quite useful to talk about budgeting for unknown disputes and unknown problems year on year.
I mean, I think the ideal, obviously, for clients is probably for them to have the before the event insurance to be covered, that they don't have to worry about those things. The likelihood of that is, you know, is minimal, sadly. So in terms of budgeting, it's the first thing we do when we're looking at the scopes and we're trying to work out for clients is you've got the case, the likelihood of success and how it is, but it's also looking at what position the client's in terms of their business. You know, very often, I think I said before, litigation can be thrust upon people, as well as, you know, it's not always just a company deciding that there's been a debt for 2 years and now they're going to action it. Very often it's brought to them very immediately, and our ideal would be there to be this lovely sort of litigation war chest in the background just in case, but that's not really realistic with businesses. You know, they like to use the money they have, and litigation has potentially large expense attached to it. So I think in terms of budgeting, it's the scope that I talked about before is not just for the initial piece of work. It's as soon as we know what type of claim there is, we need to have conversations with clients about the likelihood they're going to run the case to court. You know, will they ever? Or is it simply that they want to assert the strongest case possible with a view to resolving it by a mediation or another alternative dispute resolution method? Or is it that actually they want potentially to see it through to court and trial if that's necessary? And depending on, you know, where they fit with that is when we can start to budget how long these things will take and how much they'll cost. So I think we can help clients budget, but it's very much dependent upon where they find themselves when the litigation's starting and how much they're willing to see it through to the end. Do you think, Wayne?
Yeah, I absolutely agree with all of that. But for those listening to this that aren't as familiar with the litigation process as perhaps others might be, the courts in the last 5 to 10 years have adopted a far more hands-on approach in terms of budgeting. So parties are now expected to submit what we call a Preston H budget early on in the litigation process, which is quite an extensive document setting out what the parties expect to spend in terms of legal fees and disbursements and what have you, all the way up to trial, and it's broken down by stage, and the courts have to approve those budgets as well. So the parties can no longer enter into litigation with their clients on a whim without really understanding what the financial implications are. Now there is an upfront detailed analysis of what the spend will be, and in fact, when we're talking about alternative means of funding litigation, that's a process that we certainly at HCR would recommend undertaking even before proceedings have begun, so that the client understands precisely from the outset what their potential spend could be, and actually that helps an awful lot in terms of determining what kind of alternative means of funding might be most suitable.
Thank you. I think, you know, my own experience is that people who aren't used to dealing with disputes, you know, litigation is perceived as a bit of a dark art and a bottomless pit with no certainties in terms of outcomes other than it can be expensive. And that's what's so off-putting in so many ways, aside from the actual dispute itself. So one of the questions I've got is, how do we, when we're advising, approach deciding the basis to use to charge clients? I don't know, Simon, do you want to start on that one?
Yep, I mean, everything really at the start is to assess what type of claim, how large it is, and the chance of success, and where the client is. And I find it rare that I'm in a position where the answer's not almost already obvious. I think by the time you know your client, you assess their file, and you know what they are, where they want to go with the claim. Very much, you normally come down probably at most 2 or 3 options, and it's about knowing your clients as well. It's as Wayne said, the days of throwing headlong into large-scale litigation and telling your client it will be fine and you'll let them know how much are just long gone. And you've got to understand exactly what it is your client's trying to achieve from their case as well. And I think then it almost answers itself. And clients are far more attuned, even if they don't know about litigation. People are far more savvy now in terms of having an opinion on how they want to pay for things and how they want things to run. Again, it used to be solicitors would send you your bill and you'd pay it. It's just businesses just don't run like that anymore. That people are happy to consider these other methods to see how the risk profile matches their budget for the year and what they can pay and what they want to achieve from it.
That's great, thank you. Wayne, is there anything you want to add to that one?
No, I think that's pretty comprehensive.
Okay, great. All right. An interesting question's come in that a lot of the claims that we've probably talked about, it's about recovery of money. It's a damages claim. But if the outcome is a claim for a declaration, or it's not necessarily a monetary relief that you're seeking, does that change the funding options available? Does it have any impact at all?
I think it limits them, doesn't it, Wayne? I think it's quite significantly it limits them. It's I don't think a third-party funder is going to be that interested in helping fund a claim that risks their fees and needs to be insured if there is not an upside for them that's a financial one. It might be that they have a specific product, that there is another way, there is a benefit for them to be involved. But I think people are less willing to risk and fund costs if there is not more money from another party coming into the equation. I think still, hybrid CFAs still work well, because ultimately we might still be risking some of our fees on whether we achieve success or not. So I think as a firm, we've probably taken an approach that we're more willing to risk a certain percentage of our fees because we put our money where our mouth is in terms of achieving success. But I think you very quickly lose a lot of the funding options from third parties and so forth, or 100% CFAs.
You. Wayne, you're going to say something there?
Yes, apologies, Beth. Unfortunately, my connection dropped out just as you were asking the question. I heard Simon's answer, but I missed the question. Okay,
so where you've got a claim where you're seeking an outcome that isn't necessarily all about recovery of money, how does this impact on the potential funding options available to you?
Yes, so Simon's answer does make sense. Yeah, absolutely. I mean, I've talked a lot about third-party funding, but this probably goes for most types of alternative funding arrangements. Whichever party, whether it's a third-party funder or the law firm itself that's prepared to work on a CFA or a hybrid CFA, there needs to be some certainty around recovery of financial compensation or damages. So that the lawyers can get paid, and if there's a third-party funder, the funder can get paid as well. So if you're looking at primarily non-monetary remedies, then it probably does limit the scope of funding that's available.
Thank you. Still some more questions. We've got plenty of time still to go through this. Question is, how do I protect my business from having to pay the opponent's legal costs if we lose the case? I don't know, Wayne, do you want to pick up on that one?
Sure. So the primary way in which you protect against adverse cost orders, or in the event that you lose an interim application, or God forbid the final hearing or trial, is to obtain what we call after the event insurance. And I know a number of people on this call will be familiar with that concept, but just to clarify, your AT insurance policies tend to cover, first and foremost, your opponent's costs in the event that you're unsuccessful, but on occasion can also cover your own disbursement costs if you're working under some kind of hybrid CFA and those disbursements aren't being picked up elsewhere. Almost always these days, where we're looking at these types of creative funding solutions, AT is something that we'll be talking to clients about, and part of that conversation will be the type of AT insurance policy that's obtained, whether it's a policy that's paid for up front, or a deferred premium where it's paid for out of the damages recovered. As a general rule of thumb, the policy premiums tend to be that much higher if the premiums are deferred until the outcome of the case, as you'd expect. They're almost self-insuring, which sometimes makes that kind of deferred policy arrangement unattractive. But by and large, they're either regarded as just a really good idea, or are a prerequisite insisted upon by a third-party funder.
Thanks very much, Wayne. Simon, did you want to add anything to that?
No, I think it's pretty comprehensive, but it's definitely, people have to accept that you can insure, you can do all these things, but there does have to generally be a small element of risk in litigation. Obviously, ATE policies, especially if they're self-insuring, almost remove that. But it's people also understanding really what they're getting into with litigation, that it's not non-contentious or transactional like they might have dealt with before. It's something particularly difficult which somebody's going to have to end up paying for.
Thank you. I think we've talked about sort of wave situations where funding may be available, but what we haven't touched on yet is the assessment process and what's involved in deciding whether a case is suitable for funding, whether it could be approved. And so I don't know if perhaps Wayne, you want to pick up on who funds the upfront disbursement costs before funding can be considered as approved or as a potential option.
I'm happy to jump in here, Simon, but obviously add benefit of your experience, because I think it will depend on the type of claim that you're looking at and the appetite in the market to fund the piece of litigation. So where a prospective case has really good prospects of success, and you're talking about damages in the tens of millions, and recovery looks fairly straightforward, i.e. assets haven't been hidden in offshore trusts and what have you, then you'd expect the number of funders to be queuing up around the corner and possibly offering to pay for all of those upfront disbursements that you talked about. And just to clarify, the main disbursements that you'd incur before you set off on your litigation journey and before you obtain funding would be, as I mentioned earlier, the barrister's opinion giving a good prospects of success. So that's a claim that should win at trial, and also possibly an asset report on the defendant, evidencing where monies and assets are held, so that they can be targeted upon obtaining a judgment. On occasion, where claims look less attractive to the market and perhaps prospects aren't quite at 60-70%, or recoverability looks difficult, then there can be a reluctance in the market to take on the responsibility for those disbursement costs speculatively. And so then there needs to be a conversation with the client as to how to fund those. And again, there's a range of solutions available. Sometimes, an agreement can be reached with the with the barrister concerned, or the research agent, or asset tracing agent that you employ to compile the report. So there are a number of ways of doing it, but I mean, obviously the best way is for a funder to fund all of those costs on a speculative basis without any commitment up front. Like I said, that only tends to happen where you've got, you know, a really, really attractive case.
Thanks very much. Another question that's come in is we sort of talked about some cases as if they're very big ticket in terms of value. But what sort of the options, or what do you recommend as options for the sort of smaller pieces of work, sort of more day-to-day types of disputes in terms of sort of medium moderate value? What are your thoughts on that?
I think litigation funders are usually less interested in smaller claims. I mean, I honestly think they'll consider anything that's reasonable as long as it's within their band. Most funders, you know, haven't understood or even expressed quite clear band of what is their target market for the types of cases it deals with. You have some funders who specifically will only deal with certain claims over tens, 20s, millions, some who like to be in the region of 5 to 10, and some who will deal with much smaller matters. So I think it depends very much on, as Wayne was saying, you know, have you already assessed the merits? Do they have funding? Do they have assets and so forth you that aren't out of the jurisdiction or difficult to get hold of or hidden? But if it's going to be a small piece of work like this, I think it's again driven by what the client's position is, how prepared they have been with their funding and budgeting to have money for these pieces of work, and what they're going to get as a result of the work. I mean, it would be great if, most third-party funders have some funds within them that they're allowed to use at discretion for counsel's opinion. But again, like Wayne said, unless it's a case they feel like they're going to be fighting other funders for, and there's such a good chance that they want to be the one slightly ahead by helping fund the council's opinion and being at the front of the queue. I think for small pieces of work, you're far more likely to be at sort of set fee and hourly rates and so forth for those types of work, especially if they're the ones that will decide whether the cases are run really thereafter.
The one thing I'd just layer on top of that is that having worked at a number of commercial law firms in my career, HCR does adopt a really pragmatic and solutions-focused approach to funding. So where the value of a claim perhaps isn't sufficiently high to attract third-party funders, we do look at, as Simon's already mentioned, hybrid CFA arrangements and potential other sources of funding as a means to unlock claims that might otherwise sit on the shelf. So there is no claim that we won't look at, or at least assess and do what we can to like I say, unlock it.
I mean, why do you think most people still choose sort of hourly rates when there are these other options? Do you think it is depending clearly on the value of the claim and what have you? But it seems to be, in my experience, there's only a handful of certain cases where clients are really interested in exploring funding options. They seem to want more certainty and stick with the hourly rates and whether say capped fees, what it might be. What's your experience of that?
I think that as I mentioned a moment ago, that I think primarily comes from a misunderstanding of the market, or an outdated understanding of the market and how competitive it's become. Ultimately, these funding solutions do result in a successful claimant receiving slightly less than the other side otherwise would if they'd self-funded. They have to share part of the upside with the funder, or on a CFA with the solicitors acting for them. So I think that's the reason why a number of potential claimants, their default view is that they should fund it themselves and keep the whole of the pie when they win it. Yeah.
And I think as well, you were asking Beth about why hourly rate as well, and I think it's fine for it to be assessed on hourly. I think not enough firms understand or are willing to go down a hybrid CFA route and put their money where their mouth is a little bit. Whereas, as Wayne's already said, a hybrid CFA is almost always one of the things we consider for clients. But I think people litigation is stressful enough for some people, and they just go with what they think is the norm and what's easier and simpler. That there has to be discussion documents signed for some of the other methods, so they just default to the hourly rate, and if they can't afford it on the hourly rate, then they just don't do it. And there's so many good claims that can be brought if clients were more aware that they can be run on these hybrid CFAs and on these different forms of agreement. There'd be a lot more litigation that could be sort of successfully achieved for them that otherwise either gets written off or just is left to simply run out of limitation. So I think it's a little bit it's about educating people that just because you're not going down the hourly rate route doesn't make it that much more complicated or difficult. It's just different to what they might have heard of or be used to.
Yeah. Another perhaps historic misconception is that claimants will lose control of the litigation where a third-party funder is involved. But of course, there are strict rules around champity and their involvement in the decision-making process. Inevitably, if in the course of litigation, if the parties attend mediation and some form of compromise is presented on the table, then the conversation with the funder will form part of that process, because the funder may be prepared to take less than they might otherwise contractually be entitled to take in order to buy themselves and the client certainty. So there are situations in which it can become a tripartite negotiation, including the funder. But my experience is that funders are very commercial entities, and they're also very cognizant of their role in litigation and the need to avoid depriving the clients or claimants of their independence when running litigation.
And I think it's pretty rare, isn't it, that we have a client who, if they get into third-party funding, they're already normally quite commercially minded, and what they want out of a claim is usually almost identical to that to which the funder wants. It's rare we get funding for a claim where somebody feels a moral point that needs to be taken to trial and they need to have their day in court. People who use funding are generally more commercial already, and I think, like you say, it's pretty rare we ever see a situation where the funder wants one thing and the client wants another. Usually they're very much working out quite at what stage it should be settled and for what amount, rather than them actually having different views on it.
Really helpful, thank you. So, I'm just conscious we've got a few minutes left. I've got one last question here. You talked around the various funding arrangements available and how we approach things, but how can we, or what do we do to ensure that the funding arrangements that are offered are actually competitive in the market? Because it is a moving feast at the moment in some ways. When you said, the market's evolved and things are more competitive than they used to be, and so that view that people may have had thinking, no thanks, greedy third-party funders, or I'm not interested in hybrids, I want more certainty. There's a lot on offer in the market at the moment. So how do we keep an eye on what's competitive in the market at any one time?
I'm happy to jump in. I'm sure Simon knows the market as well, if not better than I do. Yeah, no. So I'll give the benefit of my experience, and I think it'd be equally important for Simon to share his. But first and foremost, we as litigators, I think, or commercial litigators especially, have an obligation to understand and keep abreast of what's going on in the market, what products are available, and what terms the players in the market are offering at any given time. But I'm also always conscious that scouring the market and going to extreme lengths to understand the precise terms that all funders might be able to offer is a full-time job. It's not something that we as litigators can spend all of our time doing. So there is always a role I think for brokers to play in this playing field, and we work closely with a few leading brokers in the UK, who obviously work internationally, and keep close to those so that we understand from them, fully what options are available. And we can always, and our relationship with those brokers is such that if we have a funding option on the table, we can benchmark it against what they could potentially attract from the market more widely. So brokers do have a big role to play, I think, and actually the number of brokers in the market, like the number of funders, has increased in recent years, and that profession has become that much more sophisticated and switched on. So it's they provide a really useful tool for us, is probably the short answer.
I agree, and I think also it's important that we do everything we can. The brokers will, but the clients also. Usually, if clients come to us already knowing about funding, they've already got a funder they want to use, and understanding how they arrived at that, whether it's someone that another business has used, someone they've used previously, because certain funders have specific focuses, should we say, in areas and types of cases as well. And it's important that clients understand that just because a funder was very good on one type of case, then maybe not at all remotely the most appropriate. And whilst we can give guidance and so forth, that's not part we can advise on. So the clients also have to understand that there's an element for them to understand the funders they want to use and what they want to get from it as well themselves.
That's really helpful, thank you. Well, I'm conscious it's just before 2 o'clock. As I say, we keep these sessions fixed to 1 hour so that we don't take you away from, I know how busy you all are. So I'd like to thank Simon today for his presentation and for fielding questions, and also thank you to Wayne as well. It's been really useful insight into cost funding, and thank you for joining us. If you have any questions that you sort of come out of today's session, our contact details are available. Please do drop us a line. As I say, Simon, Wayne, or I will come back to you quickly, and we'll be able to I'm sure, help you. As I say, and I do hope you can join us for the next in this series of monthly Q&As. But for now, thank you very much. See you soon. Bye-bye.